Hello everyone, welcome. My name is Jamie Gilpin and I will be your host today for our event, which is our webinar on the current state of immigration, where we've been and where we're headed, presented by Envoy. For those of you who don't know us, that's me. For those of you who don't know Envoy, we are the leading immigration services provider. We combine expert legal representation with technology to ultimately provide the only enterprise platform that enables companies to effortlessly hire and manage their workforce across borders. So that's everything from navigating U.S. immigration to securing global work authorization and business visas around the world, to ultimately ensuring compliance by tracking and managing all of your international employees and expats. And we do that for over 1,000 companies across many industries, locations, and company sizes. So a few housekeeping items before we get started. One, the session is being recorded, so we'll be able to send you the recorded session for your reference, and then of course to share with others in your organization. The presentation will last probably today anywhere between 30 and 45 minutes. And so we will have some time left over for our Q&A. So if you do have questions that you would like to pose to Ian, who I will introduce in just a second, please do so in the question panel just to the right of your screen there. And we will be monitoring that, and then I will be reading those to Ian at the close of the presentation. So as just a high-level agenda, really excited about today's webinar and content. We have been receiving quite a few questions and concerns from our not only our HR partners and employers, but also their foreign national employees. And so there has not been any lack of activity that's gone on over the last 10 months or so in regards to immigration. This is definitely the height of what I've seen in this industry over the last few years. And so what we will do is just take a deep dive into all of the changes that have happened from January to today, and what you as employers should know, and possibly what you should be communicating to your foreign nationals or your sponsored employees. But the main event here is really Ian Love, who is our main speaker today and a great partner to Envoy. He is an attorney with Global Immigration Associates, which is the law firm affiliated with Envoy. And he has built and submitted hundreds of non-immigrant and immigrant work visa petitions. Extensive experience handling B's, E's, H's, L's, O's, TN's, alphabet soup of immigration here in the U.S., as well as employment-based green cards. And actually, and especially as of recent, which we will talk about, extensive experience with the USCIS and specifically requests for evidence or RFEs, which have increased pretty significantly this year, which Ian will cover. And so we are lucky to have Ian on. He is extremely busy, as are most of the or all of the attorneys now at GIA, mainly because of some of these changes that have happened within policy within the USCIS and government of recent, but also one of the more favored attorneys there at GIA, countless just compliments from his customers and clients. So we're lucky to have him on to explore what has happened to date and perhaps where we're headed. So without further ado, Ian, I will hand it over to you to talk about the executive orders on the travel bans.
Great, thank you, Jamie. And hello, everyone. As Jamie said, my name is Ian Love. I'm one of the attorneys with Global Immigration Associates, a law firm that works with Envoy to provide services through the platform. And what we're going to do is we'll be covering at a high level some of the major events in what has been a tumultuous year so far in the immigration sphere, and still has 2 months to go, so there may be yet more to come before the year is out. But we'll cover what's happened so far at a high level to give you a general idea of trends that are developing, things you may need to be aware of going to the future, and what the future may hold in coming years for this space. So the first item that we'll cover is the travel ban, or perhaps travel bans, I should say, because it's been through several different iterations. We have on the screen here a timeline of the first few weeks of the Trump presidency, in which there have been, which we went through the first iteration of the travel ban, which has gone through several cycles, which have looked more or less similar as we've gone through them. So what we have seen so far is that within a week of taking office, Trump issued an initial travel ban barring barring admission to the United States of citizens from Iraq, Syria, Iran, Sudan, Libya, Somalia, and Yemen for 90 days. Very shortly after that, there were legal challenges filed against this travel ban, primarily by states, and a large part of the legal grounds that states are alleging in their filings against the travel ban have been losses that they will suffer from harm to their businesses in the states, harm to state universities, which will be losing out on tuition revenue from foreign students, and other financial harms that the states may be suffering through the inability of citizens of certain countries to enter the United States. So the cycle that has followed since then has been a travel ban is issued, an appeal is filed, federal judge will issue an injunction or restraining order against the federal government enforcing the travel ban, and then now 2 or 3 times subsequently, and we can advance to the next slide, Jamie, 2 or 3 times subsequently, the administration has come back with a new travel ban, trying to address some of the issues that had led to the injunctions being filed against preventing enforcement of the earlier version of the travel ban. Some key points to take away, I think, from the travel ban is that each iteration of it, as it has been different and has tried to address the administration has tried to change it in a way that would make it enforceable and not allow the injunctions that have been issued against the previous versions. And one major takeaway also, which I think is very important for thinking about in terms of how this may affect your workforce, is that the countries included in the travel ban have changed with each iteration. So in the first version, Iraq was included. Iraq was then removed from the second version of the travel ban. And in the most recent version, Jimmy, if you would advance the slide again. In the most recent version, the countries included are Iran, Syria, Yemen, Somalia, which have been included all along. Iraq is back on the list for this most recent iteration. And then we see 3 countries that have not been added before: Chad, North Korea, and Venezuela. And for some of those, I believe Chad and Venezuela in particular, this has not been a blanket ban on citizens from those countries, but has rather been targeting particular individuals. So with Venezuela in particular, it has been specifically aimed at high government officials from Venezuela, given the tensions going on between the United States and the Venezuelan government currently. So that was the most recent iteration of the travel ban, which was issued in September. The latest developments hot off the presses with the travel ban has been that last Friday, a judge out of the U.S. District Court in Hawaii issued a nationwide preliminary injunction against enforcement of this travel ban, which had been scheduled to go into effect last week. The government earlier this week then filed a notice of appeal against this injunction, and that's where we stand at the moment, government preparing its appeal against the injunction. So this is a topic that will continue to develop over the coming weeks and months, I'm sure, and something that we'll be keeping on top of and advising our clients about any important changes that they need to be aware of. So the travel ban, is certainly the item that has gotten the most press among all of these in the normal media, but there have been some other developments which have not attracted as much attention broadly, but which do have a big impact potentially on employment-based immigration and for both the employees who are foreign national employees and for the companies that work for them. The first of these items that we'll discuss is the in-person interview requirements. So specifically for green card applications. So previously, in-person interviews had not been required for people who were applying for adjustment of status, that is to change their status from a temporary one, such as H1B, to a permanent resident green card holder status. But starting October 1st, in-person interviews are now being required for all people who have applied for employment-based green cards, as well as their family members who are applying along with them. The implementation of this is retroactive to cases that were pending as of previous date, which I don't remember offhand exactly, but I believe it was in March or so. So applications that were filed as of a certain date will be subject to having interviews. So the interviews only started at the beginning of this month. This is a situation that has only been happening, therefore, for a few weeks. And so we have very little information on how the process is being carried out at this point, but from some preliminary reports that we've heard from clients who have gone through interviews, as well as from other attorneys who have accompanied their clients on interviews, what we've heard so far is that the interviews have not been difficult. That employees have been asked very basic questions about what's the job you're being sponsored for, what are your qualifications for this position, and then making sure also that if there's a spouse applying along with the employee, that is a bona fide marriage and not a sham marriage entered into to help the spouse get a green card by piggybacking on top of the employee who's being sponsored. As we continue to receive more word about these, it's something we will keep on top of as well. One other thing that we've heard as well is that some of the officers who are conducting these interviews seem not to have been very well trained on the requirement, that they're asking questions that are more relevant to family-based immigration rather than employment-based immigration, for which family-based immigration has required interviews in the past. So officers are more used to conducting interviews focusing on those areas. So there have been some issues with questions that are not really pertinent being asked to people who are interviewing for employment-based green cards. We do suspect that this is going to lead to a slowdown in green card processing times. Traditionally, the processing times for green card applications at the final stage at which the interview takes place have been highly unpredictable. Most people on average would take about 6 to 8 months to receive their green card from the time when they submitted their application. Because of this interview, and we do suspect that there are going to be capacity issues with the USCIS not having enough staff to effectively and timely process the interview requests, we do suspect that this will lead to a slowdown at this final stage of the green card application process, and particularly in areas of the country where there is a particularly high volume of employment-based green card applicants. That would include like the Bay Area in California and other major cities, especially with the cities with large tech scenes, Chicago, New York, Seattle, due to simply a very high demand for green card applicants who are residing in those areas. So the interview requirements have also been added to people who are applying for permanent resident status after previously being admitted as refugees, and USCIS has indicated that there may be further incremental expansions to more and more categories of green card applicants. So we can move to the next slide, Jamie. Next item and one that we have been paying particularly close attention to is the Buy American, Hire American executive order. This was issued by the Trump administration back in April, and it was not a very specific order at the time. It was simply directing the government agencies that are implicated in employment-based immigration to be investigating their practices to make sure that U.S. workers are not being disadvantaged through employment-based immigration processes, and more broadly to ensure that employment-based immigration laws are being rigorously enforced. In particular, a lot of the focus has been on the H1B program, and there are potential ways in which we may see some changes. There could be changes to the prevailing wage structures. There could be changes to more rigorously define what positions are going to be eligible for H1Bs. But as of now, this executive order has been on the books for about 6 months now. So far, all that has happened really directly attributable to the executive order has been information gathering and publication of information. USCIS has been publishing on its site They put out a list of all employers who filed H-1B petitions in recent years, and they also recently put out a list of all employers who filed L1 intercompany transferee petitions in recent years as well. This information had been previously available publicly, but not in such a condensed format. So people who were interested in finding this information could have gone online, and if they had known where they were looking for, could have found it and known what are the employers who are filing these petitions, how many petitions have they been filing, and so on. But now this has all been aggregated into a single location that's easy to find, where it's easy to find. So any company that has filed an H-1B petition, their name is on a spreadsheet on the USCIS website that is publicly available. It also contains information about average salaries I believe that those companies are paying to the H-1B employees that they've sponsored, and the types of positions that are being sponsored. We can advance to the next slide. USCIS approval policy updates. This one is hot off the presses. This just came out on Monday. So since 2004, USCIS has had a policy by which when an employer was filing to apply, was applying for an extension of work authorization for the same employee in the same position that had previously been approved, the officer reviewing the extension application was to defer to the fact that the case had been previously approved and really only question the substantive aspects of the previous case if there was evidence that a clear error had been made, or if there was new information that would warrant a new determination. That policy was rescinded effective immediately. Just this past Monday. So now officers reviewing these extensions with the same employer and same employee applications are instructed to review them as if it's a fresh petition and remake an eligibility determination from scratch. Because this has now been in effect for 72 hours or so, something we haven't yet seen any impact from. To speculate on what it could lead to, though, we think it could lead to more requests for evidence and potentially even denials when, if the officers feel empowered to question the conclusions that their colleagues had reached previously in approving the case initially. The area where I suspect that we may see the most impact would be on H-1Bs and then also on L-1Bs. L-1B adjudications with USCIS have been very difficult for coming on 10 years now, with very inconsistent and unpredictable adjudications. But one upside had been the fact that once a person was approved for L-1B, if they were filing for an extension in the same position with USCIS, the extension was fairly straightforward. That policy has now been rescinded, so we may see an increase in difficulty in renewing the L-1Bs as well as H-1Bs and potentially other categories as well. So another policy change that has come full circle now is the H1B Premium Processing. So for those who may not be aware, the Premium Processing is a service by which certain types of petitions filed with USCIS can include an additional processing fee, and then you're guaranteed a response within 15 days of when USCIS receives the petition, rather than waiting potentially months for the normal adjudication times. Starting at the beginning of April, which was right when all of the H-1Bs for the annual lottery for new H-1Bs were submitted, USCIS suspended premium processing for H-1Bs due to a severe backlog that had accumulated. Gradually, over the course of the summer, premium processing was reinstated for different types of H-1B petitions, and then at the beginning of this month, it was fully reinstated and it is now available again for all H-1B petitions. This did lead to some slowdowns in overall processing compared to what some petitioners may have expected, some employers may have expected during the summer. But the backlog seems to have been cleared out now, especially with premium processing available. Premium processing available again. Those employers who need it can again access it for H-1Bs. And this was only a suspension for H-1B premium processing. It did not affect other categories that that were also eligible for premium processing. So for example, L1s, I-140s as part of the employment-based green card process, where the premium processing remained eligible for those categories throughout the summer. Okay, we can move to the next slide. And then starting in, it was really about in July, so about 3 months ago now, there has been a significant spike in the number of RFEs, which is a request for evidence issued by USCIS, and particularly on H1B cases. So an RFE is issued by USCIS when officer reviewing the case determines that they do not have enough information to render a final determination on the case in the initial filing, so they request additional documentation or information from the employee or the employer, or both. There has been no official statement on where, what is the reason for the increase in RFEs issued this year. But as a practical matter, it does seem that this is an outgrowth of potentially the Buy American, Hire American executive order and the general directives coming from the administration to impose increased scrutiny on the H1B program. So the bump in RFEs has happened nationwide. It has not been confined to any particular geographic area, any particular industry, any particular country of origin for the foreign national employees. But it has been seen uniformly among all H1B petitions filed. The types of information being requested at a high level have been more details about the job, so that USCIS can determine, is this a sufficiently sophisticated occupation or position to qualify for H1B and to meet H1B's requirements. So one thing that I've been asking clients to do, and that I'm sure some of my colleagues have been doing as well, is before we're filing new H1B cases, to provide more details about the job description, really go into specifics about what technical skills are required, what competencies are necessary to adequately perform the duties, so we can make a stronger case up front that this job is indeed sophisticated enough to qualify for the H1B category. Some of the things that have been appearing in these RFEs have been, to put it lightly, I would say misguided. One of the most common things we've seen is when the employer certified that it is paying an entry-level wage in the labor condition application that accompanies the H1B petition. USCIS has been saying that by stating that you're paying an entry-level wage, this means that this person is relatively new in the occupation, and therefore that calls into question whether the job is sufficiently sophisticated to qualify for H1B. I say that these requests are misguided because they are without any foundation at all in the laws that create and guide the H1B process. And in some ways, they seem almost to be defying common sense in some of the requests that are being issued to us. But this has been a new change in policy that came about unannounced, that we're seeing significant numbers of these RFEs targeting entry-level wages. And I should say that we have been successfully responding to many of those. So we do have solid legal arguments to respond to those, to that allegation, which, as I said, is really without any strong basis in the law that underlies the H1B program. So another one, which like the travel ban has gotten a good amount of media coverage, is DACA. For those who may not be familiar with the program, in essence, what this was a program created under the Obama administration that allowed people who had been brought here undocumented as children and met certain conditions regarding not having a criminal record, being enrolled in school, or serving in the military, or other ways of which showing they were being productive members of society, to allow for work permits that would apply for work permits and for protection against deportation. On September 5th, the Trump administration announced that effective March 5th, the program would be ended, although there has been a lot of political wrangling going on since then to try to make an extension to the DACA program. so the protections against deportation and work permits would not be rescinded for these employees effective next March. Then we did go through a period that expired on October 5th, during which people who had expiring DACA permits could apply for a renewal, but that date has passed, and now applications for either new DACA permits or renewal of an existing DACA approval are no longer being accepted. We can move on to the next slide. Enforcement. So enforcement has been a big theme coming from the current administration about immigration. There's been a significant spike in the number of immigration arrests compared to last year, and compared to the Obama administration, which had determined to focus its immigration enforcement and deportation efforts on people who were deemed a danger to society, who had criminal records or other similar background issues. The Trump administration has taken the position that essentially anyone who is found to be unlawfully present in the United States is subject to removal. So that has come with a significant increase in funds focused on enforcement, including hiring new officers and immigration-focused prosecutions as well. We can move on to the next slide. So in terms of how has this enforcement taken shape, there's demand-side enforcement under the current administration. There's been particular focus on targeting employers who hire unauthorized workers. There has been, in recent years, there had been less focus on audits of I-9s. That is the form, of course, that employees fill out when starting a new job to verify that they are authorized to work in the United States. But we suspect that there may be an increase in I-9 audits, so it's particularly important for employers to make sure that they're filling out their I-9s correctly and keeping them up to date when necessary. There have been attempts by the federal government to partner with other federal agencies and also with state and local law enforcement to implement some of the immigration enforcement, although there has also been significant pushback from many local governments saying that they will not cooperate with federal immigration enforcement because they don't want to damage the trust, among their police departments and communities by deputizing their officers to enforce federal immigration law as well. There has been this, so enforcement, as I said, has been more at the company level as opposed to individual workers. There have been, among my clients, I know I've seen an increase in reports of situations where they've received site visits from a USCIS inspector, although all instances that I've seen from my clients at least have been announced in advance. There are some situations in which unannounced site visits can occur, but in the ones that I've experienced with my clients in recent months, they've actually received an email from a USCIS officer saying, we have some questions we would like to ask you about this employee. Please let us know a convenient time when we can come by and do that investigation. And that has worked out well for the employer as long as they've made sure that they are being fully cooperative with the officer conducting the inspection. Now we can move to the next slide. Fraud and National Security Director, this is actually not new. It has existed since 2009. And this actually, I should have advanced the slide a little earlier because this actually really addresses what I was speaking about a moment ago, that there can be site visits from USCIS to make sure that employers are complying with the terms and conditions in the H1B petitions that they filed for their workers. To give a little more detail about the couple of examples that I experienced with a couple of my clients, really what happened was that the officer was simply asking questions to verify that the employee was indeed working in the position that had been listed in their H1B petition, that they were being paid the salary that had been listed in their H1B petition, that they were working at the physical address that had been listed in their H1B petition, essentially making sure that the employer was indeed meeting the conditions that it had laid out in the H1B petition. We can move on to the next slide. So questions that we receive, of course, in light of a climate of increased enforcement is what can we do to stay safe? At a broad level, the tips that we can give you are carefully, of course, follow all instructions that we send to you with the various parts of an application, whether that be for the beginning of the case or the final letter that you receive at the point when we send you an approval notice at the end of the case. Periodic internal self-audits can be very helpful, making sure that your I-9 files are complete and that that you also, for H1B employees who have a public access file, making sure that all necessary documentation is in those. H1B workers are required to be given a copy of the labor condition application that supported their H1B case by the first day of employment. So making sure that you have a policy and practice in place whereby those employees will always be given the documents, a copy of the LCA on their first day of employment. Not mentioned in the bullet points on the slide here, but one that I think is very important is creating awareness within the company among both foreign national employees and their managers in the HR department that for foreign national workers on visas such as H1B, L1, in particular H1B workers, changes in the employee's employment may often require an amended petition to be filed with the USCIS before the change can take an effect. That includes changes in such things as could be a promotion or a lateral move. It could be a change in the physical work location where the employee is performing their job. It could be if the employee is moving from working all in the office to working remotely from home. Any changes of that nature could require an amendment. So it's important to create awareness within the company that those changes must be presented to the HR department so they can consult with us at a very early stage to determine if an amendment is necessary before the change is made. Situations that companies need to avoid are where the HR department finds out that a particular individual received a promotion only after the promotion has taken effect, as that could jeopardize the employee's ability to continue working, especially if a site visit were to occur during that time and the officer were to find that the employee is working in a position that was not listed in their petition. At a more broad level, we can work with employers if they have any particular questions about the practices and the procedures that they have set up within their organizations to ensure compliance with the legal, make sure that they're being compliant with the terms of the petitions that they filed for their employees. So whatever questions people have in those areas, we are happy to work with those on an individual basis to make sure that you have all of your I's dotted and T's crossed. And I believe that was the final slide, if I'm not mistaken. Yeah.
That was it. Thank you so much, Ian. That was a crash course because it feels like even more happened than that. But those were all of the major things that happened over the last 10 months or so. So we do have a little bit of time for questions. There are just a few that people have posted, and I think mostly just some clarification on some points. The first one, I think you actually addressed. They're asking about, they saw a recent news piece on H1B and L1B extensions are just more highly scrutinized and even being denied. I think the bigger question is really, and that was the memo you talked about that was just released on Monday, but I think the bigger question is what's required for petitioners to ensure their existing workforce are not affected. I think this is probably just a general recommendation, if you have it, Ian, just around the strength of those petitions, because I think we just actually were highlighted in a SHRM article about this today, and Allison, our immigration solutions partner here, said, hey, and previously maybe employers kind of treated these extensions with a little, not that they worked less or worked not as hard on them, but they assumed that they would, kind of go through knowing that the first one was approved, but to really treat these stuck-in extensions as if it is a first application. So any insight or advice just broadly on that?
So even though this policy of deference to previous adjudications had existed for 13 years, we had still always provided similar types of evidence in extensions that we provided in the initial one. So we have never been providing like slimmed down applications from the initial one. And in fact, we generally would also provide, for example, an L1B extension for a specialized knowledge employee, additional documentation from compared to the previous or compared to the initial filing to show that not only did we say 3 years ago when we filed this initial petition that this person has specialized knowledge, here is documentation and information to show that this person has been using this specialized knowledge while being employed with our company in the United States. So for us, I don't think this is going to change our process of preparing the cases all that much compared to what it has been previously, although we may ask in some situations for more detail really to make sure that we're providing the strongest possible application, including examples of the employee's work, any updates and how the employee may be utilizing his or her advanced knowledge in the company. So the biggest thing you can, I'm sorry, go ahead.
No, go ahead.
So I think the biggest thing that employers can do is just be ready for to produce increased levels of documentation and information, perhaps compared to what may have been required previously.
Great. Yeah, I think that's a great message, and one that I know very much, and our customers know about GIA, but that's not always the case with other immigration providers. So, so I guess just putting more emphasis on the documentation, right, and the evidence and proof. Another question: what would happen to the stamps that have gone under administrative processing for several months now? I don't know exactly what that's in reference to, but is there any hope that they'll be processed any sooner? Has there been a backlog of that?
So administrative processing, those are going to be highly case specific. So what administrative processing is when an employee is outside the country and has gone to a U.S. consulate in their home country or another place abroad to apply for a visa that they need to re-enter the United States. If the officer at the consulate determines that they don't have enough information to issue the visa, they'll put the case into administrative processing. And the reasons for that can vary widely. On the worst end, it could be that the officer thinks there was potentially fraudulent information presented in the petition under which the employee is applying. In other situations, it could simply be that the employee forgot to include a necessary piece of documentation on their first visit to the consulate, and it's just a matter of the employee getting that additional document, bringing it back, and having their visa issued. So because the reasons why administrative processing can be issued are so variable, it's hard to give a general estimate of how long a particular case would take to be resolved. We had been, I think, earlier this year, we had some concerns that the increase in administrative processing there might be a significant increase in it. I, to this point, have not noticed among our clients really any increased rate in issues with applying for their visas at consulates abroad. So for whoever asked that specific question, I would say that's one that you would have to discuss with the particular attorney because it would be so fact specific what happened in this person's case. Okay,
great. And then there are a couple questions on the in-person interview requirements. One, at what stage, and I know you went over this, so just probably repeating it, at what stage in the green card process do the in-person interviews occur? And then I know this is relatively new, and you mentioned even the officers are not too familiar with even the questions they're supposed to be asking, but have we received any insight into the types of questions or what people should be prepared for?
So the in-person interview happens, it's at the very final stage after the employee files their own form I-485. When that occurs is highly variable depending on the person's country of origin. In particular, employees who were born in India or China have the longest waits. It could be, in some situations, 10 years from the time when their green card process is started until they reach that stage. Employees from countries other than India and China generally might have that get to that point roughly 1.5 to 2 years from when their green card process is started. And in terms of types of questions, preliminarily what we've been hearing is the questions have been about making sure that the person is indeed intending to accept the job for which they've been sponsored, that they have the necessary qualifications for the job. And then there could be other questions that are more individual specific. For example, if a person has any kind of criminal record, they may be asked about that. People who may have performed military service for their home country may be asked about that, ask for provide details about the background in their military service. So those who do not seem to have any issues in their background that might be of concern from a security perspective, based on what we're seeing so far, I think that those people will have a fairly easy time in interviews. But people should simply come to the interview prepared to discuss, anything in their background that might be of a potential concern to the government, and be very familiar with the details of the job for which they've been sponsored. So there will be no doubt that they do indeed intend to take that job and that they have the necessary qualifications for it.
Okay, great. And then there are a couple questions on the slides and the recording. Yes, we will be sending both the slides and the recording out to everyone in an email following this webinar, so look out for that. And then a couple questions on, do you have any recommendations, templates, or sample awareness communications for HR or managers to use with their employees or foreign nationals? The answer is yes, we do. We do actually help on a case-by-case basis. So reach out to your customer relationship manager, your CRM, or customer support, and we'd gladly help you construct the messaging to help you just communicate that to your foreign nationals. There's also a question on advanced parole. We didn't talk too much about this, but there's actually been some articles out there that advanced parole petitions are being refused, and how, what are recommendations on traveling abroad if they have emergencies? Is this something that you're seeing at all?
So advanced parole in the employment-based immigration context comes up at the final stage of the green card process, again, the I-485. Advanced parole is something that an employee can apply for optionally that allows them to travel while their I-485 application is pending. Some employees can still continue to travel even without the advanced parole, but some will require advanced parole in order to be allowed back into the country after traveling internationally after they submit their green card application. So this didn't make it into the slides, but what has been happening in some instances is that USCIS has been denying advanced parole applications if the person departs the country before before the processing on the advanced parole application has finished. As I mentioned, some people have other documents that allow them to travel even without advanced parole, but some do need to have the advanced parole in order to travel. So it's very important for employees when they're at that stage of the case to make sure that they are communicating to us any international travel plans they have within the next, I would say 6 months or so that we can be aware of any limitations that we they need. So we can make them aware of any limitations and potentially time the filing of their application to accommodate any essential travel plans. Yeah.
That's exactly what we're hearing. So thank you for clarification on that. I know that was an important question. There is a question or two on the difference between different types of visas, so like the difference between H1Bs and L1Bs. So this was a webinar meant for more advanced. And so we have tons of content actually and a very quick guide on the ABCs of immigration on our resource center. So you can go to envoyglobal.com/blog or just go to Envoy Global and go to our resource center, and there are some pretty big differences, especially between that H1B and L1B, including if you've got offices abroad. So check that out if you want more information on that. And I think those are the majority of our questions, which brings us right on time to 1:45. Ian, thank you so much for your time today. We know how busy you are, just with the increase in requests for evidence and complexity of these cases. So thank you to you and to GIA, Global Immigration Associates, for your time. And of course, a big thank you to all of our attendees for taking time to just learn about these policy changes, what you need to do to kind of ease some of the questions and anxiety that, of course, is being brought on with your employees. And, of course, as always, reach out, post the Communication Center if you have any specific questions. As Ian mentioned, there are quite a few case specifics that would dictate, recommendations or in general, just any any advice to people. So please post that to the Communication Center or reach out to your CRM if you need any more help with content or help ways to communicate to your employee base. So thank you again, as always, from all of your friends here at Envoy.
Thank you.